before Mr Hoff carries on, we've got the documents that your Lordship's asked for, and we thought we'd give them to you now. It's agreed we'd give them to you now in case there are any questions arising that you may want to ask Mr Hoff for.
Morally, it's probably easier if you sort them out beforehand.
Sorry.
Thank you. Thank you very much. So I see. So what we have is, well, you're about to tell us what we have.
You ought to have section 45.
Yes.
And you ought to have the Lloyd's Law Report Court of Appeal decision in Braganza.
Yes.
And my lords and my lady, you will want to be looking at paragraphs 15 and 16, which are the significant paragraphs, the operative paragraphs, and the ones that I think were referred to by Lady Hale. And you should have two, Moss, my lord's judgment in Moss, and the paragraph there that your lordships and your ladyship may wish to look at is paragraph 27, and that's the systems point that Mr Bunting was nudging me about.
So that really illustrates simply that, as is often the way when judges recall their own cases, it turns out to be irrelevant.
Well, I wouldn't say irrelevant, but it's simply an illustration of a case where there's been a criminal trial. Your lordships concluded that that wasn't sufficient. There had been an internal investigation on systems failures, but it didn't have the necessary character of independence, and that was a matter that required determined consideration. And there is also, I hope, an example of a set of narrative directions questionnaire. My Lord Justice Davies asked for an illustration. This is just one example from a practitioner's guide, a real inquest, but a series of illustrations. And I'll let you look at it, but you'll see from paragraph 5 onwards there are issues about intent and the standard of proof. Then on paragraph 9 onwards, for example, it permits the jury to have regard to other matters, or matters that it thinks may have contributed, concludes may have contributed to death. So there is a discrete set of questions focused on establishing intent, but only to the requisite standard.
With the word sure being in bold print.
Yes.
My Lord's.
Thank you very much.
My lady, before I return to the flow of my submissions, may I hand up the original record of inquest signed by the jurors? One thing my lady will immediately notice is that it does doesn't contain the notes, and that's standard.
Thank you very much.
Records of inquests completed by coroners and juries, and then available thereafter to others, don't include the notes. And when one thinks about it, that's not very surprising, because it would rather fly in the face of the coroner's role in filtering down, for example, short-form conclusions, and leaving only those which the jury could properly consider, if they're given a document which gives, under Note 1, a full set of potential short-form conclusions. The notes are there to assist the coroner in giving directions, but the version of the form, which is, as a matter of practice, completed, contains the only the parts which appear above signature of coroner and jurors, and then the signature sections.
So that's common ground, because I noted Miss Monaghan is saying the record of inquest would have included the notes.
And I think I was wrong about that.
Yeah, just my opinion.
It is, yes. What you say makes perfect sense, but
My lord is asking whether that complies with Rule 34.
yes.
Well, that's, I suppose, a matter of statutory construction, and whether using Form 2 is complied with by using the part that appears above the notes. And of course, the parts actually to be completed are all the parts above the notes.
Well, as you say, it is a arid point of statutory construction.
The Chief Coroner points out to me that, of course, the relevant parts for the purposes of Rule 34 in making the determination and findings are sections 1 to 5, and then the table with 6 columns.
Well, with great respect, I will try and resist spending a lot of time on this point. It says using Form 2. It doesn't say answer the questions which you can find in Form 2. And it could be said that the notes are not just for the coroner, they're for the jury, and of which perhaps the most important is Little Roman 3. But there we are.
Yes.
There's not a lot that can be said about it.
Well, obviously, if your lordships and my lady dictate another approach will no doubt be followed by coroners. But I think that the reason that
Well, on that footing, I don't like too much at this point, but the notes are not there to be applied by the jury, because the jury are not free to decide for themselves if it's accident or misadventure or industrial disease or whatever. They will have been directed.
exactly that
What selection is open to them.
that was the point I was making, perhaps inarticulately at first, which was that that it rather flies in the face of the coroner's role as a filter to give the jury only the short form verdicts that they can properly return on the evidence, if they're given a list of lots of others.
Yes, no, if it were a good point, it would be a point of complete aridity, I do see, and I'm sure we can find a way around it by construction.
Not unknown for points of complete aridity to have to be decided in courts of law.
I'm not going to comment on that. May I return to the flow? I was just dealing with cases on the standard of proof before evidence. And I just wanted to show your lordships one or two of those. The first is the case of Ex parte Thomas, which is at divider 9 of the bundle. This involved the body of a deceased person being found in a river with no evidence that the person had been depressed or other direct evidence of suicidal intent. The verdict of suicide was quashed. And if your lordships observe 1476 and 1477,
Sorry, I have it.
the cases which the Lord Chief Justice relied upon were Ex parte Lockley and Southall civil case. And at G, the main proposition is identified. The coroner.
I'm so sorry, I don't have it. Is this Evans we're looking at?
Sorry, this is Thomas.
Oh, Thomas, I'm so sorry. Which tab?
Divider 9. If you're
Divider 9.
Sorry.
No, thank you.
And at 1476G, the submission which is ultimately accepted is formulated as suicide isn't to be presumed. Indeed, presumption is against it. Must be strictly proved, not merely as a matter of probability. But then, the way that the court deals with it at 1478 is this. Letter A, in my judgment, this is a plain case in which the coroner is saying that because there was no satisfactory evidence of accident, therefore it must be a case of suicide, albeit that there was no satisfactory evidence of any suicidal intent. That's a wrong approach to the matter, and an order of certiorari should go to quash this inquest. And Mr. Justice James agrees at H, right at the bottom of the page, if it be the case that questions of accident and questions of suicide arise, as arose here, mere fact that accident wasn't established doesn't mean to say that suicide is established. So that is one of the early cases, as I say, drawing upon the civil cases and saying that the error into which coroners shouldn't fall is to find suicide simply because a particular form of accident can't be identified. And then if I can take Your Lordship's engagement very briefly back to the case of Barber you've already been shown, which is at the next divider, Authorities 10. That was a case of caretaker who'd fallen from the flat roof of a three-storey building, and in the absence of an accidental explanation for the fall, the coroner reached a suicide conclusion. And you have been shown 1313 C to F, which is the Lord Chief Justice's reasons for quashing the suicide verdict there. But what I would emphasise is what he says at letter F, that in the case where suicide hasn't been proved by evidence, but there isn't satisfactory evidence to establish another conclusion such as accident, the job of a jury and the proper job of a jury or coroner is to return an open verdict. And that's really consistent with my point that these early cases are primarily concerned with the proposition don't presume suicide or likely infer suicide from the absence of other proven causes. Then from the mid-1980s, we have the cases which did start to deal with standard of proof directly and in terms. There is the case of Evans at divider 12. It was an unreported case. So, for example, in the case of Hopper, which you looked at, Evans, as far as we can see, hadn't been cited and certainly isn't referred to. In Evans, this was the tragic case of the man on the railway line who'd been seen standing in the path of the train. And Lord Justice Watkins, of course the same judge in Grey, at page 5, identified two separate errors on the part of the coroner, not directing the jury about the law of presumption and not directing them about the standard of proof. Now, what he has to say about presumption flows from the cases considered in the prior paragraph, Thomas, Lockley, Southall and Davis. But what he has to say about standard of proof is entirely new. And then the next consideration of the issue of standard of proof in time is the Gray case, although it's a few tabs later in the bundle.
But you would, it may not matter for our purposes, you would accept that Evans, the passage Miss Maughan refers to, is a direct finding that the criminal standard applies.
Yes, yes. Although he says that the balance of probabilities shouldn't apply, and he doesn't use the words criminal standard. The substance of it is that the criminal standard applies. Absolutely, absolutely. Yes, unquestionably part of the ratio of that case. Gray is the case of authorities divided 17, and is the case about unlawful killing. The case of somebody who died in police custody, and a verdict being quashed based on misdirection, including the lack of a direction on the criminal standard of proof. And if your lordships and your ladyship go back to page 477 in that authority, Lord Justice Watkins again explains that the criminal standard of proof applies to suicide, and it's unthinkable, as he says at letter H, that it shouldn't also apply to unlawful killing, which is, if anything, a more serious finding. And this is a significant comment in the light of one of the questions my Lord Justice Davies was asking earlier. At letter H, he says, "I think it equally unthinkable, if not more so, that a jury should find the commission, although not identifying the offender of a criminal offence, without being satisfied beyond a reasonable doubt." So it's the association of criminal liability with the criminal standard. The reason that I suggested to Ms Monaghan that you be shown also the top of page 478 is that makes it clear that Lord Justice Watkins is not concerned with a sliding scale in the direction that should be given to the jury. He is concerned with them being directed that the criminal standard applies to these two conclusions, suicide and unlawful killing. Now separately, if your lordships, my lady, just go to divider 13, after Gray, we have a case called Armstrong, decided by a Divisional Court of Lord Justice Wolfe and Mr Justice McCulloch. And this is a case in which neither Evans nor Gray was cited in the judgment, at any rate, but by reference to the Thomas case, Lord Justice Wolfe finds that the criminal standard applies. And we see that at 777, just above letter F. There's never a presumption of suicide, and a verdict of suicide is only justified if the coroner concerned is satisfied so that he's sure that is the proper verdict. And the one authority cited in that regard is ex parte Thomas. So we have the slight peculiarity of this case not relying upon Evans or Gray, but around the same time deriving a heightened standard of proof from the early cases. And for your note, the Divisional Court in Ex parte Walker, Authorities 15, cited Armstrong as authority for the proposition that the criminal standard of proof applied to suicide, but without any real analysis. And then The only other case I was going to go to was the case of McKerbin because of its importance. That's divider 80. Now this concerned a shoplifter who'd been restrained by police and had died from asphyxia. A misadventure verdict was returned and was upheld by the Court of Appeal. And the argument, as you've seen, was that the coroner had wrongly directed the jury that the criminal standard of proof applied to unlawful killing. And the Court of Appeal said that that direction was correct. And I just wanted to run briefly through the reasoning, because the submission is made, the submission is recorded at 723E and G. There is then a discussion of the statutory provisions going over from 723 to 724. And what one then sees from 724G through to 725 and on to 726 is a citation of Hornall and Khawaja, both of which articulate the old view of the law that in civil cases there was a sliding scale of proof in which the more serious the allegation, the higher the standard of proof. One then sees from 726G through to 727F, citation of the passage from Gray, and then the conclusion at 727G that there is a sliding scale of proof in civil cases, the high end of which is very similar to the criminal standard, functionally similar. So, an important case, but one in which there is a little muddle in the reasoning when you look back at it through the prism of modern understanding of the law of the civil standard of proof. But at 728A, in my submission it is clear that the conclusion is that the criminal standard of proof applies to determinations of unlawful killing. Well, Justice Wolfe is not here just saying this might be some helpful guidance to a jury in applying a civil or criminal standard. He says that the appropriate direction which the coroner should give to the jury is the simple one, that they should be satisfied beyond all reasonable doubt, or so that they are sure. And it's on the basis of that that he upholds the direction. So for that reason we say that McKerbin does decide as a matter of ratio that the criminal standard applies to unlawful killing and is binding on this court, subject to the exceptions in Young and Bristol Aeroplane, which we've put in the authorities file. I have to say, we don't identify any of those exceptions as being available here.
And you say that remains so, notwithstanding that McKerbin necessarily wasn't dealing with Article 2 Middleton kind of considerations.
We do say that because, as my friend has already said, there have been a number of cases, certainly in the Strasbourg courts, one thinks of a case like McCann, the Death on the Rock case, where the Strasbourg court was looking at an inquest held under our law with the criminal standard of proof applied to unlawful killing, and didn't identify any vice in that system from an Article 2 perspective. And one can see why that's the case, because an inquest, or indeed a criminal trial that determines criminal liability on the criminal standard, coupled with an inquest which resolves all the other key issues in the case on whatever standard of proof, will satisfy the Strasbourg standards, which are of course obligations of means rather than ends. McKerbin also, I don't need to go into this in detail, but McKerbin also gives guidance on how to direct juries when they're being asked to consider short form verdicts with different standards of proof. And this is something of a response to my Lord Justice Davies's point. You ask them to consider the verdict with the higher standard of proof first, and then the verdict with the lower standard of proof. So, for example, if suicide and accident are both being left to the jury, you ask them to consider suicide first. If they conclude that they're not sure that it's suicide, they then ask whether it is probably accident. And if they say no to both of those questions, they return an open verdict.
Well, what if their view is probably suicide?
Well, let me give a practical example of this.
Just ask the question, what if their view is probably suicide?
Probably suicide, open verdict.
They can't record it. It's probably suicide.
If suicide is determined on the criminal standard of proof, if the Divisional Court is wrong and Evans is right, then yes, they can't record it. Now,
not really satisfactory, is it?
I agree, and that's why I'm going to what I'm going to come on to when I deal with arguments in favour of the Divisional Court's approach. But let me give Your Lordship's and Ladyship an example from the unlawful killing context, which was in the New Cross fire, which was quite a famous event. There was a further inquest in the 1990s, and the judge, His Honour Judge Butler, said that he couldn't be sure that the cause was arson, but he thought that it was probably arson. So he explained that in his ruling, and he returned an open verdict, and the open verdict was upheld. Mr. Justice Hughes.
Well, let's take the same example, but using unlawful killing.
Losing suicide.
So under the McKerbin approach, you ask the jury, are you sure? If the jury are not sure, then they're not allowed to comment at all on probably the unlawful killing.
The reason why we say that there is potentially a problem with suicide and not potentially a problem with unlawful killing in this regard is that unlawful killing is something of an anomalous verdict. It's a verdict that reaches a conclusion of liability in a system that isn't normally about determining. It's a conclusion that reaches a determination of liability in a system which is not normally concerned with whether liability exists or not.
Well, it doesn't. It doesn't say who is liable, and you might therefore say a finding of liability against no one isn't really a finding of liability.
True, but the point I was making is that depriving the jury of the opportunity to return a finding of unlawful killing because of the standard of proof doesn't stop them finding fact. Depriving them of the opportunity to find suicide
does deprive them of the opportunity to find fact.
That's too subtle for me. You can easily imagine verdicts of unlawful killing, murder, which are wholly dependent and only dependent on factual findings.
Absolutely. But in an inquest context, and this isn't a subtlety, this is entirely practical, in an inquest context, a jury, or a coroner or jury, will not have to determine that X killed Y for the purpose of a set of factual findings. They're not allowed to name an individual. There is no difficulty about finding that somebody died from stab wounds or by being run over by a car, or whatever, on the civil standard of proof, while not being able to return an unlawful killing verdict, which is essentially a finding of law about the presence of criminal liability, except on a criminal standard of proof. I'm slightly preempting some submissions here, but that's the point we make, that a finding of unlawful killing may justify the higher standard of proof, even if suicide does not, because suicide may be necessary may be practically necessary and certainly logical to have all the components of a suicide finding in the factual determination of the circumstances of death. But answering how somebody died does not necessitate saying that there is or isn't criminal liability.
Surely the more elementary distinction is that unlawful killing connotes a crime,
Yes.
whereas suicide does not.
Yes. Yes.
And while we're on that point, before we just move away from the curtain, sorry to shoot these questions at you, I think Miss Maughan submitted a 728D to E. She, I think, suggested that may be part of the ratio. The situation is that just as it is important that a jury should not bring the verdict of suicide as a short, likewise they should. Do you have that 728E?
Yes.
Would you say that with regard to suicide is part of the ratio of McCurtain? Or would you say that's simply a side fact?
We would say it is not part of the ratio. It's a step in the reasoning to have considered, because the court has had to consider the way that other verdicts are addressed. But as I read it, the court isn't saying that as an essential component of the conclusion, suicide must be to the criminal standard.
So it's a step in the reasoning, but not a necessary step.
Yes.
Well, they've already announced that conclusion before referring to suicide,
Yes.
you can point out.
Yes.
Yes. Sorry, Lord Justice Walpole.
Now, the other case I was going to refer to, and I wasn't going to take your lordships to it, was the Sridharan case, because it's the other Court of Appeal case. I don't think it was suggested that binds my lords and my lady to find that the criminal standard applies to suicide. The principal complaint in that case was that the coroner had not carried out a proper inquiry, because the coroner had focused his inquiry too much on the prescribing practices of the doctor. And it was in that context that the question of whether he should have directed his inquiry more at suicide and ultimately considered a suicide verdict came up. As I said earlier, the correctness of the criminal standard of proof for suicide never came up, either at first instance or on appeal. And as we read paragraphs 71 and 72 of Lady Justice Hallett judgment, she doesn't suggest that the higher standard of proof was essential to her conclusion. That's divided 33. May I turn now to arguments in favour of the Divisional Court's approach?
the essential conclusion is that the civil standard of proof applies to suicide conclusions, whether short form verdicts or as part of narrative determinations. We say that there wasn't any bar to the Divisional Court taking that approach, and that there is no obstacle to this court doing so. We say the legislation doesn't mandate any particular standard of proof. Now, the effect of Note 3 is, of course, a matter of statutory interpretation. But we say, as a matter of construction, Note 3 was not mandating laying down a standard of proof which should be applied, as all our immediate reactions was on first reading that note. It would be a very odd way for a rulemaker to mandate a particular standard of proof, not in the body of the rules, not even in the form itself, but in an explanatory note. The other notes to the form are permissive or mere guidance. Notes 1 and 2. You may use one of these short form verdicts, you may use them in combination with a narrative. And a logical and reasonable interpretation of the note is that it was serving the function identified by Lord Justice Leggett, that of explaining the law as it was understood to be. Secondly, there is no authority at Court of Appeal level in which an essential element of the reasoning for the decision was that the criminal standard of proof applies to suicide.
Sorry, just before we leave note 3, you don't take any point on Viries. So supposing it was in fact purporting to lay down what the standard of proof would be, would Section 45 cover such a provision?
Yes, it would. Both because it is very broad in its terms, and because the other rules which were made under Section 45 cover a very wide range of practice and procedure. There is nothing about the standard of proof which falls outside the rubric of practice and procedure in an inquest, and there is nothing in the primary legislation which either mandates a particular standard of proof or purports to preserve standards of proof as a matter for primary legislation.
I don't want to take a point that nobody else seems to want to, but there is a certain amount of case law about what is meant by practice and procedure, because that comes up quite often in the rule-making powers for other tribunals, both the High Court and other statutory tribunals. And I certainly can't think of any other case, although I can't claim to have looked at it looking for this, where rules made under general powers of that sort have said anything about the standard of proof. My instinctive feeling is that would be a matter of substantive law rather than of procedure, but I can see you could argue it both ways.
Yes, I've come across that sort of issue in other contexts, but not on this point, as Statutory says. As I say, if we're right about the construction of Note 3, then the problem doesn't arise.
Quite, but if you're not.
But if we're not, then it is potentially important. And we're very content to look into it afterwards if it's a matter that's exercising.
Well, it may only be exercising me, but because this is an important case in which perhaps it's worth going down every alley, if they turn out to be blind alleys, I think it would be useful to see if there's any general law about what the phrase practice and procedure covers when it's used to give a rule-making power.
Well, may I preserve the right to put in something, a note afterwards
Yes, I would only ask if you're going to do it, can you do it fairly soon?
Yes.
Yes, thank you.
So against that background, there are three broad arguments to be made in favour of the Divisional Court's approach if there's nothing binding. My lords, my lady. The virtue of applying the civil standard of proof to short-form and narrative findings of suicide is that it avoids both of two anomalous results. It avoids the result that a different standard of proof applies to a short-form suicide conclusion, as distinct from a narrative saying that the deceased person killed him or herself deliberately. And in answer to one of the questions raised by my own friend this morning, as to whether that's illogical, the point really is this. If there is a policy rationale for applying the criminal standard to suicidal intent in a short-form verdict, that policy rationale surely applies with equal force to a narrative verdict.
I think Ms. Maughan will go along with that.
Yes. Yeah. This part of the Divisional Court's approach is a virtue which Ms. Monaghan's approach also shares. It's a virtue not shared by the coroner's approach. And as I've already submitted, there's no magic in the difference between short form and narrative verdicts. They are both simply ways of answering the statutory questions. Secondly, the second anomaly, and the one which is not resolved by Ms. Monaghan's approach, is the Divisional Court's approach avoids the result that separate findings in a single narrative determination are reached by applying different standards of proof, or that certain factual issues are ruled out of consideration in a narrative determination. Quite apart from any practical difficulties this may cause in directing juries, it gives rise to, or it may give rise to, objections of principle. So findings about contributory causes of death in particular may be dependent on findings about the intentions and acts of the deceased. In a case of apparent suicide in prison, there may be issues about whether the prison authorities properly foresaw and took precautions against the risk of suicide. In that context, whether a person in fact intended to kill him or herself may obviously influence findings about such foresight and precautions. Equally, a finding that a person was very determined to kill him or herself may be relevant to whether precautions would have made a difference. Now, there are two problems with the approach which is being suggested by the claimant. The first is that there will be cases in which it will be said that intent, the deceased's intent, is a key issue which ought to be resolved in any narrative determination for it to be complete. That excluding a finding of intention is going to leave an account of the circumstances of death with an important element simply missed out.
Well, not only that, because as we all know, sometimes having to leave things out cannot simply result in an omission, it can result in a distortion.
Yes, it can. And then there is also the separate practical difficulty that a jury would be asked to consider suicidal intent for the short form verdict, perhaps, according to a criminal standard of proof, and then turn to the narrative verdict where they would decide the same question according to a civil standard of proof, but not say anything about it, because they would only be considering it for the purpose of its relevance to other findings, which would be a very odd exercise for them to be engaged in. And I appreciate that the suggestion will be made that the key issues in the case can be resolved through a combination of the short form determination and the narrative. But it will leave, as my Lord has indicated, narratives omitting an essential, what some people will say, certainly in Inquest, is an essential element of the story. It would undoubtedly be argued in some Inquest that intent is one of the key issues that must be resolved by the narrative. The point can also be made, as a matter of practicality, that my own friend's argument for the criminal standard of proof to apply to findings of suicide in a narrative doesn't make clear exactly what findings must be returned to the criminal standard. Take an overdose case. The finding that there has been an overdose, civil or criminal standard. The fact that it caused death, civil or criminal standard. Or is it only the finding of intent that is returned to the criminal standard?
That would be a considerable task for anyone.
Yes.
I don't adopt the views that are expressed in respect of juries in these cases, but for anyone that would be a difficult task.
Yes. It's not that one denigrates juries,
No,
one simply
on the
needs to
contrary.
make their task not too much of an exercise in metaphysics. The second argument in favour of the Divisional Court's approach is that there are good reasons of principle for the civil standard to apply, and we've identified 5 in our skeleton at paragraph 46, which substantially overlap with what the Divisional Court says. First of all, an inquest is an inquisitorial proceeding whose object is accurately to find and record the answers to factual questions. In that context, why should the rules make it more difficult for certain purely factual findings to be made and appear as to the cause of death and the circumstances?
Sorry, what was the reference in your skeleton?
It's paragraph 46.
Yeah,
These
thank
are all
you.
set
Yeah.
out. Secondly, one public good served by inquests is that they contribute to reporting of deaths, and they produce reports on prevention of future deaths, making it more difficult for suicides to be found by a heightened standard of proof risks under-reporting of this cause of death. And my lords and my ladies, you don't have to take my word for that. That was something reported in the fundamental review of the coroner's coronial system. If you'll note, Authority 63, page 135, paragraph 53. Thirdly, the criminal standard, as applied in criminal courts and in civil committal proceedings, can be said to reflect the very serious potential consequence for an individual, both the seriousness of a finding of criminal liability in itself, and also the justification for the state to satisfy a high standard before applying criminal sanctions. Fourthly, findings with serious consequences, as your lordships have observed, may be returned in civil cases on the balance of probabilities, and those may include findings which bring shame and stigma, including that a person deliberately killed him or herself. Any notion, of course, that special standards of proof should apply to serious or stigmatising allegations has gone with re H and re B. And fifthly, the early cases on suicide findings, such as Lockley and Thomas, expressly drew upon the approach in civil cases. Similarly, in other jurisdictions, the courts have sought to assimilate standards of proof in inquests with those of civil cases.
Say that again?
The first point is that the early cases drew on, in our jurisdiction, drew on the civil cases. The second point in that regard is that in other jurisdictions, there has been a tendency to assimilate the standards of proof in inquests or death inquiries with those in civil cases. And the third broad argument we make in favour of the approach taken by the Divisional Court is that the authorities don't offer a convincing rationale for the criminal standard being applied for suicide rather than the balance of probability standard. So first of all, the preference for the criminal standard emerged in Evans, Gray and Armstrong. And in all those cases, the court based the adoption of the criminal standard of proof on the line of cases which had said that suicide wasn't to be presumed in the absence of some other explanation. But none of those early cases, which the judges drew upon, said anything directly about the standard of proof. They were all consistent with the civil standard being applied. And the judges in all those earlier cases were mainly concerned about the problem of coroners inferring suicidal intent from a clear accidental explanation of death. And the point can fairly be made that one doesn't need the criminal standard of proof for that purpose. One simply needs an appropriate direction of the jury. The next point about the weakness in reasoning is that there has been an attempt in later cases in commentary retrospectively to suggest a rationale for the criminal standard of proof to apply, but those reasons have also had their difficulties. Some cases, such as McKerbin, have suggested that the criminal standard eases the task of directing juries, and that point is made in my friend's written submissions. There are several points to be made in that regard. First, most findings of suicide are made by coroners sitting alone. Secondly, coroners' juries have other important findings to make on factually complex issues, but do so applying the civil standard. Thirdly, juries hearing civil cases, defamation, police actions and the like, are often asked to apply the balance of probability standard. And fourthly, it's not peculiarly difficult to direct a jury to apply the civil standard, but not presume suicidal intent from the lack of an unobvious accidental cause of death. By comparison with the other directions coronial juries have to grapple with, that would be easy. Compare the direction on self-defence with its subjective and objective elements, or some of the directions given to juries about diminished responsibility. And also, of course, bear in mind that my friend's solution has its own problems of directing juries. And finally, in relation to directing juries, as a reason for weighting the standard of proof, ease of directing juries counts as a pretty poor reason of principle. In other cases, it's been said that the criminal standard of proof should be applied because suicide carries a particular stigma. And I've largely dealt with that point, but there are three answers to it. First is that the civil courts use the balance of probability standard to reach equally stigmatising conclusions, including conclusions of suicide, which are, and which may be, highly publicised. Secondly, as the Divisional Court pointed out, attitudes to suicide in our society have changed since the time it was a criminal offence. It's certainly a matter of shame and stigma for some families, but other families are more concerned to have an accurate conclusion from an inquest. And some families, especially in prison cases, are more concerned to have a suicide recognised, along with the failures of the authorities to prevent it. And of course, coroners and inquest juries return other conclusions which carry stigma or blame applying the civil standard of proof. An adjectival finding of neglect, that death was caused by natural causes contributed to by neglect, for example, is available where death has been contributed to by a serious failure to provide food or medical care to a person in a dependent position. A finding of that kind may be highly distressing to a family, to a professional carer, to hospital staff. And in Article 2 cases, a critical finding may effectively cast blame on public authorities or their agents. Before completing those submissions on the Divisional Court's approach and what recommends it, I should also say that it's been adopted as authoritative in the High Court of Northern Ireland in the very recent case of Stepanavicienne, which we've put in the file at Authorities 44. I don't take you to it.
That's Lord McCluskey's case?
Yes, I believe so.
That's confined to suicide?
That is confined to suicide, and in fact, for your note, paragraph 66, he makes the point that unlawful killing did not fall to be considered in Maughan, and nothing about unlawful killing was an indispensable element in the debate and reasoning of the court. That's last page, page 31, paragraph 66. May I turn to arguments in favour of the claimant's approach? And I'll do so more briefly, because my own friend has advanced them fully and ably. But there are a few points I'd like to elaborate on the Chief Coroner's behalf, while again stressing that his own approach is non-partisan. The first is that a large body of authority has built up in which the criminal standard has been found or taken to apply to findings of suicide. As to the cases which preceded ex parte evidence, the point can fairly be made that some of the comments of the judges went further than merely saying that suicidal intent should not be too readily inferred. You've already been taken to some of them, but there is the comment of Lord Widgery and Barber saying that there was no single fact which definitely points to the deliberate taking of this man's life, 1313E. And in Hopper, the Divisional Court drawing on Barber and referring to the need adequately to exclude the possibility of an unexplained accident. My friend can fairly make the point that excluding possibilities and looking for definite proof suggests a heightened standard of proof, and that it was not a long step for the courts in Evans and Gray to conclude that the courts had been talking about a criminal standard of proof. And it's also fair to say that in the cases that followed Evans and Gray, many experienced judges readily accepted that the criminal standard applied to suicide conclusions, although my lords and my lady aren't bound by those cases. Lord Justice Wolfe in Armstrong and McKirbin, Lord Justice Bingham and Mr. Justice Leggett in Walker, Lord Justice Lloyd in Nutt, Lady Justice Hallett in Sridharan, no doubt being cast on principle in any of those. And my other friend can also make the point that although McKirbin is only binding in its conclusion as to the criminal standard for the unlawful killing verdict, or even if that's my lord's and my lady's view, the reasoning of the court drew upon and accepted as its foundation the application of the criminal standard to suicide. The second point that may be made on my own friend's behalf is that, the claimant's behalf, is that the concern about the particular stigma resulting from the unvarnished short-form conclusion of suicide is one which echoes through the authorities. It's in Gray at 477D, it's in Kendall, Mr. Justice Simon Brown at 1191H to 1192A, it is in Lagos, Mrs. Justice Lang at paragraph 37. And suicide may be said to be an unusual verdict in this regard. Survives from a time when such verdicts could have devastating and immediate consequences. And also as a label, it has an acute capacity to cause distress. For that reason, both the Wright Committee in 1936 and the Fundamental Review of 2003 recommended that it be replaced with a more neutral conclusion stating that death had resulted from a deliberate act of self-harm. Such a conclusion would, of course, carry no necessary implication about the intention of a fatal outcome.
But isn't that emphasis on stigma in some of the cases, in fact, rather unbalanced, because it is only one factor? There are many other factors which an inquest is designed to address, trying to get at the truth.
Yes.
And if some unpleasantness results on the way, then that is, I'm afraid, the price we pay for trying to find out what truly happened.
Yes.
And it might be said that case like Gray always put far too much weight on the stigma aspect and leave aside all the many other reasons for an inquest.
I suppose the point that might be made against that, and I don't for a moment suggest that there's not force in that, is that in answering the question how somebody died, speaking about their suicidal intent and doing so in the label of suicide is peculiarly stigmatising without adding a great deal to the factual picture. Thirdly, the argument can be made that there are rational grounds for distinguishing between inquests and civil proceedings in this regard. In a civil action, the courts are trying to strike a fair balance between the competing interests, often, of course, economic interests of parties to a dispute. And as Lady Hale said in the Re B case, the balance of probabilities reflects the idea that the consequences of a wrong decision are reasonably equally bad either way. By contrast, an inquest serves a different purpose. It's the principal means of death investigation, recording the causes of unexplained and controversial deaths. A short form conclusion is entered in the register of deaths as the state's authoritative statement of the cause of death. Furthermore, in an inquest, the affected family has more limited rights of participation in and influence over the proceedings than if they were parties to a civil action. They can't require a witness to be called, only ask coroner to do so, and the coroner's decision will only be reviewable on Wednesbury grounds. They can't make an address on the facts. Their rights to disclosure, while more extensive than they were at one time, are less than those of most civil litigants. And overall, the family in the position of the Maughans might fairly say that a high level of proof should be reached before the state authoritatively records this death as a suicide based on a process in which they have had limited rights.
But those who participate in inquests aren't really sensibly called parties.
They're not interested persons.
They're not. That's why the analogy just doesn't work. Because in a civil action, you meaningfully can talk of parties.
Yes.
In an inquest, you can't, because it's contrary to the whole nature of an inquest to have parties.
Yes. In a sense, then, that argues against, that speaks against the analogy with civil proceedings either way. And then, of course, my lords and my lady can review also the Braganza case, which, while concluding that, while recognising that findings of suicide in civil cases are determined on the civil standard of proof, added the interesting comments of Lord Hodge, which you looked at paragraph 61, where he said that the nature of the contract of employment, a relational contract, might mean that the employer requires particularly cogent evidence before being satisfied of suicide, since unlike a judge, the employer can sit on the fence. That was one of the passages which you were shown earlier. It might be suggested that there is some similarity between that and a coroner who can return an open verdict. In addition, the law in other jurisdictions shows that our courts aren't alone in reflecting concerns about the stigma attaching to suicide findings or in adopting the criminal standard of proof in inquests. Ms Monaghan and Mr Bunting have identified in their skeleton the position in a range of jurisdictions, but what we would particularly add for your Lordship's information is that those which apply the civil standard also seem generally to have adopted the sliding scale approach, whereby a higher standard is taken for serious allegations such as suicide. And for your note, that's Re Beckon, an Ontario case, page 176 and following. Re Sutherland, a New Zealand case, Authorities 38, page 251. And Anderson and Blaschke, a case from the state of Victoria, Authorities 37, page 7. May I now turn to arguments in favour of the coroner's approach, which again I'll do so relatively briefly. The coroner in this case understandably relied upon guidance in the coroner's bench book and in a guidance note issued by the first Chief Coroner. May I ask you briefly to look at the bench book? It's actually in the authorities file at Divider 46. Now, the reason the bench book wasn't a matter of discussion at the inquest directly is that the bench book isn't a public document. It isn't available online. Although obviously if a coroner was going to draw upon it, he or she would circulate the proposed directions in the usual way. But the part on which the coroner relied, we see at pages 23 and 24, which is part of a specimen directions that starts at page 21, summing up in a prison death.
So, sorry, which paragraphs, which pages?
So the relevant part of this specimen direction, page 23 in the bottom right, paragraphs 20 and onwards, there's a direction on suicide, which includes a direction against presumption and a direction on the criminal standard of proof. And then the narrative direction which is said to be appropriate if either you can't decide deceased's state of mind or you find that his mental condition caused him to be incapable of forming an intention, or where on balance you find he intended to take his own life but you cannot be sure about it. And then a number of forms of words are chosen, and C is and on balance he intended the outcome to be fatal. Paragraph 30 makes clear that the balance of probabilities is to be applied. So in complete fairness to the coroner, his approach was entirely faithful to the bench book. Yes, my friend Ms. Hewitt very quite rightly points me to paragraph 31 as well. Which concerns additional contributory causes. Now, the Chief Coroner produces guidance and the bench book in an effort to ensure consistency of practice in accordance with legislation and decisions of the courts, which is important in a system where we have many coronial jurisdictions but no central rules committee and no practice directions. The Chief Coroner always makes clear that he may revise the bench book and the guidance in accordance with the decisions of the courts. He isn't.
As a matter of basis, where did the then coroner get this approach from? He had Gray, yeah?
Yep.
He had Evans.
Yep.
So where did this split approach derive from?
The split approach derived from, first of all, directing on suicide in accordance with paragraphs 20 to 24, which reflects Gray and Evans. The narrative reflects the understanding that a narrative ought to be able to tell a full story.
The then coroner's own thinking, having regard A to Gray and then B to Middleton and Article 2.
Yes.
But it had no, what I call, authoritative basis, apart from a view as to what was desirable or necessary.
Absolutely. The Chief Coroner at the time was doing his best to provide coroners in what is a tragically common type of inquest, with a way of reconciling Gray and Evans on the one hand, with cases like Middleton that say that a full account of the circumstances of death ought to be given in a coherent way. And the coroner was then faithfully following this. I should say, on behalf of Chief Coroner, that he fully recognises that this document and guidance number 17 may well have to be revised following the decision of this court in this case. The following points can be made in favour of the coroner's approach. First of all, it avoided the anomaly of a narrative determination, including factual findings reached according to different standards of proof. I've already addressed my lords and my lady on that, because that's an anomaly which is also avoided by the approach of the Divisional Court. The coroner's approach also ensured that the unqualified headline conclusion of suicide could only be returned and entered in the register of deaths if the evidence satisfied the criminal standard of proof. And it's worth noting, of course, that the coroner in this case, by following the bench book carefully, ensured that the finding in the narrative that the deceased intended the fatal outcome made clear on its face that the decision was being reached as a matter of probability. The balance of probability standards was written into the conclusion that the jury reached in their narrative.
The point about the register of deaths, though I understand it, has less weight than it would, since, as I understand what either you or Ms. Monaghan said, there's actually no legal obligation to enter anything, and if there is, in principle, you could enter, if there's space, the content of the narrative, or at least a summary of the content of the narrative. It's entirely a matter of practice that you put in the short form, but don't put in a summary of the long form.
Yes. Yes, it is a matter of practice. One of the oddities of the recent Hillsborough case is that we had a narrative verdict comprising many, many pages, but the registrar of deaths was persuaded to put in one conclusion from that long narrative as the conclusion as to the death, namely unlawful killing times 96.
What does the bench book say about summing up on unlawful killing?
We don't have that section, we can provide it. I am sure that it will, and I have looked at it at one point, I'm sure that it says that the criminal standard applies
Throughout.
to all ingredients of the offence.
So both short form and narrative.
An unlawful, the ingredients of an offence wouldn't be dealt with in the narrative as ingredients of an offence. So the narrative might say, did somebody die from stab wounds? But it wouldn't say, you have to follow the kind of route to verdict which a coroner has to direct a jury on as part of an unlawful killing direction.
One of the issues in unlawful killing might obviously be self-defence.
Yes.
Would it be typical, if there were a narrative, for not only factual findings being made about the facts relevant to self-defence, but about whether the degree of force was justified? Almost by definition. Well, I don't know.
There may be some. Coroners do take care to, on that particular aspect of an unlawful killing verdict, not to include in the narrative findings which would be inconsistent with the short form, and a short form is being offered. But self-defence, for example, includes the subjective and the objective element, and it's rare to see both of those being combined in quite the same way in a narrative.
Just spelling it out myself, although I'm sure you're there already. If the coroner and or the jury, are sure that self-defence wasn't available, they will make a finding of unlawful killing.
Yes.
While not naming anyone. They may or may not add a narrative which may or may not explain why they have reached that conclusion. Is that a fair summary?
Yes.
If they take the view that self-defence was probably not available, but they can't be sure, correct approach would clearly not to give unlawful killing.
Correct.
But would you expect to find in the narrative section findings about the facts relevant and perhaps a finding on the balance of probabilities that the force used was excessive?
Yes, I'm thinking back in the de Menezes Stockwell shooting case. We had exactly this problem, and their unlawful killing was not left. The jury were left with lawful killing and open verdict. They weren't satisfied that it was lawful killing, so they returned an open verdict. But they returned because, of course, lawful killing has to be established to the civil standard. But they then made some findings of fact about the situation in which the police officers found themselves in the tube train, which would probably have informed their thinking about the lawful killing verdict.
No, yes, very interesting. Thank you.
May I just go back slightly? It's just that I was looking at the bench book,
Yes.
really to see what guidance it gives, and what struck me was the absence of reference to authority in it. Contrast, for example, the Crown Court bench book, where there is a plethora of authority, so that one can take the guidance and read it from the authority. Looking at the Chief Coroner's Guidance number 17,
Yes.
and paragraph 56, standard of proof,
Yes.
it cites no authority at all on that.
No, the guidance does cite authority for quite a number of
It does,
propositions.
but not standards of proof.
No, it doesn't.
No.
It doesn't. Yes, it would be better if it did.
Perhaps somebody decided don't go there.
Well, there's that less than helpful footnote at 44, isn't there?
Yes.
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 No one seems to have done anything about it. All right.
Is it still the case? Is it still the case, so far as you're aware, that the Chief Justice are not currently considering the position?
I'm not aware of them doing so. May I just check for a moment? My client isn't aware of them doing so either. The third point which could be made in favour of the coroner's approach is that while it may be thought illogical to require the criminal standard of proof for the short form conclusion of suicide, but allow a narrative finding of deliberate self-killing on the civil standard, there are some points to be made in favour of that approach. The courts have deliberately given coroners very considerable discretion how to formulate a narrative verdict or elicit one from a jury. We've cited Middleton at 202E for that proposition. The courts have also stressed the flexibility of narratives in other respects too. For example, findings may be made as to matters which may have caused death, even though they can't be shown probably to have done so. And the possible rather than probable causative link will then be spelt out. And that's the case of Lewis, which determined that findings can be made as to matters which were possibly rather than probably causative. Authorities 29, paragraphs 28 to 29. And a narrative conclusion can therefore be cast in a qualified form, which makes reference to the sufficiency of proof for a particular conclusion. Again, that's not just assertion by me, that's also the interpretation of narratives by the authors of the Fundamental Review Report, Authorities 63, page 91, paragraph 31. So in the context of suicide, it might be said that this has particular benefits, that the narrative might say that a person committed a fatal act deliberately, but that it's unclear whether he or she intended a fatal outcome. Or it might say that he or she probably intended a fatal outcome, although there's no direct evidence of intent, thus nuancing the conclusion for the benefit of the family. May I then turn to the unlawful killing conclusion? As I've said, it's our submission that the court is bound by McCurbin to hold that the criminal standard applies to a verdict of unlawful killing. I should also say that there are other cases in this court where the criminal standard has been held or assumed to apply as part of the approach of the court. For example, the case of Sharman, paragraph 24. Sharman. Sharman was the police shooting of Harry Stanley, who had a replica gun that looked awfully like a gun. And
I thought it was only a chair leg, or am I thinking of a
yes, I
different case?
think that one was the chair leg. That's a divided 26 of the authorities. So I don't go to it, but first of all, Mr. Justice Leveson and then the Court of Appeal gave guidance on the proper approach to directing juries in these difficult cases, and at all times stated or assumed that the criminal standard applied to unlawful killing.
Well, certainly, as I recall, in Duggan, it was very much proceed on the footing. It was the criminal law of self-defence that was in play there.
Yes.
And it wasn't argued before us, but certainly, I think, I was also it was the whole case proceed on the footing that it was the criminal self-defence, or rather civil self-defence.
Well, I was going to come to Duggan a little later, but
well, I hope you will, because
it is relevant because it shows that when dealing with lawful and unlawful killing, the coroner's court is concerned purely with criminal law concepts, and moreover with certain specific homicide offences, not all homicide offences. Now, the Chief Coroner is particularly concerned that the court should be aware of arguments in favour of the higher standard continuing to apply to unlawful killing, because it's a particularly significant verdict, and anything this court says about it will be parsed by those working in the system. There is already some anecdotal evidence that suggestions are flying around that the Divisional Court's judgment in this case cast doubt upon the criminal standard of proof applying to the unlawful killing verdict.
well, it does.
Yes,
That's the side point, it casts doubt on it.
yes, but when that's being addressed to coroners as a point, coroners will need ultimately an answer one way or the other.
Is it fair to say that, despite the Chief Coroner's general neutrality, on this point, A, he wants clarity?
Yes.
That's positive. But is it also true that B, he would wish to argue for upholding McCurbin, or is that going too far?
I think what we would say, and it's a notch down from that, but what we would say is that there are good reasons for the unlawful killing verdict to retain the criminal standard, whatever your lordships decide about, and my lady decide about the suicide conclusion.
Those good reasons are?
Well, let me begin. By way of preamble, this is a verdict which has an unusual history, mostly summarised in the Wilkinson case, Authorities 1 from paragraph 27. So, before 1926, the coroner's court played a role in criminal justice, a key role, which was that if the jury found that death was due to murder or manslaughter, it would issue a special form of inquisition, which would have the effect of a bill of indictment. The Coroner's Amendment Act 1926 changed that so that an inquest would be adjourned pending criminal proceedings in a case of suspected homicide. But even after 1926, the Coroner's Court still had the power to indict individuals by issuing the special form of inquisition. So if, for example, the CPS had decided not to prosecute, then the question of homicide arose in the inquest. There could be the special inquisition operating as an indictment. That power was removed in the Criminal Justice Act 1977 after recommendations by both the Wright and Broderick committees. But that left uncertain what a coroner's court should do if it found that a homicide offence had been committed. It was the coroner's rules in 1984 that provided the answer by introducing the form of inquisition which referred to an unlawful killing verdict. And shortly after those rules had been introduced, we had the Gray and McCurbin cases establishing that the criminal standard of proof applied to that verdict. In 2003, the Fundamental Review, which laid the ground for the Coroners and Justice Act 2009, recommended abolishing the unlawful killing verdict, and it provided a new list of proposed short-form conclusions, which included traumatic death at the hand of one or more other people. That's Authority 63, page 90. That recommendation wasn't accepted, and in passing the 2009 Act, Parliament chose to retain the provision precluding a finding of criminal liability of a named person, thereby permitting findings of criminal liability which don't name a person. And that's why I said earlier that the purpose of the section being cast in those terms is to preserve and legitimise the unlawful killing verdict, which duly appears in the new record of inquest form. So against that background, we'd make 5 points for the unlawful killing verdict retaining the criminal standard, whatever is said about suicide. First, this verdict is unique in a number of important respects. It is a legal conclusion that a criminal offence has been committed, not just a factual finding or composite of factual findings. It is a finding that all the elements of a homicide offence have been proved and that there is no lawful excuse, or any lawful excuse has been disproved. It is a verdict specifically bound up with concepts of criminal law, and your lordships will see that from the Duggan case. If lords would like to turn that up, it's at divider 35.
Still on the first of your 5 points.
Still on the first of my 5 points, the unique quality of this verdict. In the Duggan case, divider 35, one of the arguments was that the verdict of lawful killing ought to be determined by reference to the civil law of self-defence rather than the criminal law. And this court disposed of that 2218 to 2219 in the passages marked. My lords and my lady, look briefly at those passages, paras 91, 93 and 94. The basis of the unlawful and lawful killing verdicts are all concepts of criminal law, and the conclusion of lawful killing, like unlawful killing, had always been understood to be linked to crime. So furthermore, as I said, it's only a verdict specific to certain offences, only murder, manslaughter and infanticide, not causing death by dangerous driving, for example, as decided in the case of Wilkinson. Now, we accept the point made by Inquest
So what cases does it apply to?
murder, manslaughter and infanticide.
Homicide cases, no.
Yes.
Not death by dangerous driving.
Not death by dangerous driving. And by manslaughter, and with manslaughter I include corporate homicide, because that would fall within
What homicide?
corporate homicide under the 2007 Act. We accept the point which has been made by Inquest in their submissions that there are some cases where a few findings of fact will justify a conclusion of unlawful killing. But that doesn't stop this verdict being a legal conclusion of criminal liability, which is quite unlike, for example, a finding of death due to industrial disease. It's also a verdict which is unusual, even anomalous, in a system which is generally not concerned with making any determinations of legal liability. It requires the court, in practice, to address and resolve questions which aren't otherwise necessary.
Sorry to be tiresome, we're still all on the...
Still on point one.
Yeah, okay, that's fine. Yeah.
It requires the court to, in practice, to address and resolve questions which aren't otherwise necessary to resolve the issue how a person died. And this is, I've already addressed this to an extent, but explaining how a person died doesn't necessarily require answering whether another person was acting in self-defence on the legal test, or whether somebody else's negligence was gross, or whether the requirements for corporate criminal liability are satisfied. So it requires the jury or coroner to go beyond the factual findings that would be required to answer the key issues as to how somebody died. Secondly, despite the prohibition on the record of inquest naming the person responsible for the homicide offence, his or her identity will very often be obvious from the evidence, and in a jury case from the coroner summing up and directions to the jury. That fact of life has been recognised in a series of cases, including in Gray itself, 479C to D, and also in the case of Anderson, Mr. Justice Collins, a judge with a lot of experience in heavy inquest cases, gave that as a particular justification for the high standard of proof. Although we are not dealing with criminal sanctions being applied, we are dealing with the state saying that criminal liability exists, and it will often be very easy to identify who is in the frame. In fact, the coroner's directions to a jury may make it entirely obvious.
I think Ms. Monaghan might make the point that you could have that situation arising in a suicide case. If someone assists the person to commit suicide, the name of that individual may be obvious from the inquest, and that will be a potential crime.
Yes, although that's only a problem in some suicide cases.
Only a problem some, but it is capable of happening.
It is capable of happening. It can, in practice, be resolved to an extent by being careful about the directions concerning the narrative verdict, if there is one. Ordinarily, juries are told, don't name individuals in narrative verdicts, because you can normally do a perfectly good job of explaining how somebody died and answering all Article 2 key issues without personalising the explanation. But yes, it is a point that can be made by this one.
And even if that does, the other point is that even if that does happen, it will not be a finding of liability. It may be an inference that anyone reading it can draw from the fact that X went and bought the drugs, or handed over the syringe, whatever it might be. But that's not a finding of liability, whereas, going back to your first point, that is a finding of liability, albeit
yes,
the person isn't named.
It is the state science saying that a crime has been committed at the end of the judicial process. Thirdly, an unlawful killing conclusion acts as an immediate and direct spur to the CPS to consider a prosecution. Now, Inquest in their submissions make the point that the CPS will often review evidence from an inquest, whatever conclusion it reaches, but a determination of unlawful killing has a very particular effect. Under the standing agreement between the NPCC, the Chief Coroner, and the Coroner's Society, the CPS specifically undertakes to consider the possibility of a prosecution after an unlawful killing verdict. If you'll note, the relevant part of that agreement is Core Bundle, page 71, paragraph 6.1. And that, furthermore, is what the Broderick Committee in 1971 recommended when supporting the abolition of the power of a coroner to commit a person for trial on a homicide offence. It said that the inquest could still serve a function by the CPS reviewing the evidence after any unlawful killing determination. And that's in the Broderick Committee report, paragraph 1627 to 1628, at Authorities 62, page 185. Now, at this point I should answer one submission by Inquest which is based on a misconception and is self-defeating. Inquest argues at paragraph 38 of their submissions that the civil standard of proof should be adopted for the unlawful killing verdict because, and I quote, the standard applied by the DPP in deciding to prosecute is closer to the civil standard. A conviction is more likely than not. Now, of course, in asking whether a conviction is more likely than not, the DPP is asking whether the evidence will satisfy a jury to the criminal standard of proof. And so the criminal standard is built into the evidential test applied by the CPS for prosecution purposes. The fourth point we make regarding the unlawful killing verdict in an inquest setting is that there are particular reasons why one shouldn't carry over the general standard of proof which applies to civil proceedings. First of all, as I've said, that the unlawful killing verdict is an announcement by the state that a homicide offence has been committed with a finding to that effect that does reach the register of deaths in practice. That is going further than a civil court making findings which may be tantamount to criminal offences having been committed. It's a finding that criminal liability exists and there's no valid defence as a matter of criminal law. The verdict, as Duggan shows us, encompasses concepts of criminal law which have no analogue in civil law, like the criminal law of self-defence. It's a finding.
Is this different from your first point?
Well, it's different. It's different from the first point in that I'm saying one cannot simply say that because criminal offence or the conduct amounting to a criminal offence can be found in a civil court on the balance of probability, that means that the same approach has got to be taken in inquests.
Yes.
There are particular reasons why one doesn't follow that reasoning process. And the final point in this regard is that the process doesn't permit the person suspected of the homicide offence to call witnesses, address the jury, or have full rights of disclosure, as in a criminal setting, or indeed in a civil setting in which they're a party. And fifthly, retaining the criminal standard of proof for the conclusion of unlawful killing doesn't create the same practical problems that are at least arguably created by retaining it for suicide. As I've said, purely factual findings can still be reached in an accompanying narrative, whereas a narrative need not and normally should not deal with all the ingredients for criminal liability, certainly not in terms of expressing it as a homicide offence or a criminal liability. So those are the points we make in favour of the criminal standard being retained for unlawful killing, whatever decision is reached regarding suicide.
Nibble again at section 10.
Yes.
Because this, and I speak only for myself, this does seem to me to be a possible indication that Parliament is connoting that a jury or coroner can make a determination of criminal liability. And if that's right, then that we tend to support the argument the criminal standard applies.
Yes, I see the force in that point. And the reason why...
And if that's right, that would tend to underpin your 5 points you've made.
Yes.
It's giving a rationale for why Parliament may have wanted to maintain that.
Yes.
And you would say criminal liability in the context of an inquest can only be an unlawful killing verdict, because finding suicide is not any kind of determination of criminal liability.
No, it's not. No, it's not. And the reason why Parliament has used this form of words is that if it simply said a determination under subsection 1A may not be framed in such a way as to appear to determine any question of criminal liability or civil liability, that would necessarily remove the basis for the unlawful killing verdict. But I agree that the way it has been put suggests that Parliament recognises that a criminal liability is being found when that verdict is returned, and is at least consistent with our submission that the criminal standard of proof is required.
Is there anything, just looking at 10.2, may not be framed in such a way as these words, as to appear to determine?
Yes.
Yeah. Anything you want to say about that?
These words have been looked at in a number of cases, and the point which has been made about them is that facts can be found
Yes.
which come close to or may strongly suggest civil or criminal liability exists. But every care should be taken that the verdict as presented does not appear to make it a determination of liability as such. That's the way those words tend to have been, or have mainly been discussed in the authorities.
So they've been discussed, sorry, say it again?
There has been some discussion of them in the authorities. I'm just thinking. Again, I'll see if I can dig something out. But
So could you just summarise again what you said to my lady?
what I said to my lady was that this phrase has been interpreted as meaning that a coroner or jury can find facts which may strongly suggest the presence of a civil liability or a criminal liability of a named person, but that the determination must not appear actually to determine that liability. And that makes sense when you think about it, because
Otherwise you could emasculate me.
exactly, you can make all sorts of determinations about failures of safety precautions and so on, which may very strongly suggest civil liability, but
Or criminal liability.
or indeed criminal liability under the Health and Safety at Work Act.
Quite. Just on that last point, reminds me, from what does one get the limitation of unlawful killing as a short form finding, determination, to murder, manslaughter and infanticide?
The case of Wilkinson addresses this very fully. It's divided 31. There was a vehicle recovery operative run down on the motorway, and the question was whether the offence of causing death by dangerous driving could support an unlawful killing verdict, and the answer was no.
We will, I'm sure, look at it, but in short form, is it just what those words have always been understood to mean, or there's not a statutory definition, or a definition in the rules?
It is what the words have always been understood to mean, there is some discussion also in the case about whether causing death by dangerous driving by its nature is an analogue to the offences which have supported the verdict.
Yes, I see. But I think that's a sufficient answer for what I wanted to ask. But I was really then just coming to make this, again, I'm sure obvious point, but I hadn't quite thought it through. Although that is the case about a verdict of unlawful killing, there is no such limitation in the application of 10.2a. One can imagine all sorts of criminal offences being relevant to a verdict, not just health and safety in a factory, It could be that someone has died from taking an overdose of drugs, which were, it is clear from the necessary findings, were supplied unlawfully by a friend or a third party, and so on. One can think of all of those. The reference to criminal liability there could cover any of those types of case.
Yes, and the words of the narrative determination might strongly suggest
Yes.
that criminal liability exists, but they won't say that a criminal offence has been committed. And that's why I distinguish between the unlawful killing verdict, which is a legal conclusion, and factual determinations which may suggest or support criminal or civil liability.
Well, one can think of it as, say, a drug addict who unfortunately takes a fatal overdose. Evidence may emerge as the name of the supplier
Yes.
that you would avoid. Not cause responsible death in that sense, but nevertheless the person who supplied drugs, and that would be something that would not appear in the jury's verdict.
Correct. What one would probably also avoid stating in terms that another person had committed a criminal offence as well.
Indeed, but nevertheless the factual matrix would be there will have been a supply of drugs.
Yeah. You could meet the letter, though perhaps not the spirit of 10.2a, by naming the supplier,
You could.
but simply not spelling out it was unlawful to sell the drugs, though anyone could work that out for themselves.
And there are situations in which naming individuals may at least assist in telling the story, and may not be an irregularity. It is
Might be
sometimes
necessary, it might be a relative,
yes,
or the person they lived with.
yes.
Could you just for my own enlightenment myself, if the jury return a narrative verdict which is expressed in a form which is considered unacceptable, there is a procedure then for asking the jury to reconsider their wording?
I've never come across the problem.
If you've got a question and answer, hopefully, but sometimes jurors might go a little bit beyond what they're meant to do. And is there a procedure then for saying, sorry, you can't do that under section?
In heavy inquests in which I've been counsel to the inquiry, we normally ensure that the jury's narrative comes to the judge and his or her team first, in order to make sure that it doesn't say anything which is legally bad.
But that happens, so to speak, behind the curtain before it's announced.
That would happen behind the curtain, so that if necessary.
So there is a procedure whereby the jury could be asked to reconsider the wording they've used.
It's never happened in my experience, but that's what we planned to do if that problem arose.
And what, in consultation with the advocates?
Oh yes.
Obviously.
Oh yes.
In the absence of
Yes, it would be in the absence. It would be in the absence of the jury. It would be subject to an order under the Contempt of Court Act to ensure the jury didn't hear about it, but it would be in consultation with the advocate's office.
Not perhaps the best of analogies, but in the same way in a criminal trial, one might deal with a note from the jury. The judge takes the note, counsel brought in, and it's shown and discussed.
Well, one gets notes from juries in inquests
Of course,
very
indeed,
often, and that's the approach taken, yes. Sorry, may I just turn my back? Chief Coroner reminds me that last year he presided over the Westminster Bridge terror attack inquest, where of course a finding of unlawful killing was made, and it was blindingly obvious who was responsible for the unlawful killing. And then, for that matter, the inquest of the attacker reached a conclusion of lawful killing, and it was equally obvious who had committed the lawful killing, although he was anonymised. I think I've covered all the ground I'd set out to.
Both inadmissible in a subsequent criminal trial.
Absolutely. Absolutely.
So justice is still done.
Yeah. Unless I can assist further, those are my submissions.
Thank you. We're most grateful to Chief Coroner for
Would it,
Interviewing
would it be
instruction.
possible at some stage for someone to hand in the relevant parts of the bench book on unlawful killing?
I'll make sure that's done.
That would be helpful. Someone could do that.
Monsieur, we've had your very helpful skeleton argument, and it's clear that you anticipated that Mr. Hough would say most of what you would otherwise say. How much is left?
Very little, and I will really hesitate to repeat anything at all. But if I may just take a short amount of the court's time, I do think it would be a benefit perhaps to clarify absolutely the coroner's position and stance, just
Yes.
in case there's any confusion about it. And if I may, going therefore perhaps full circle, coming back to the starting point for him, the court will have seen that in approaching the task of eliciting the jury's conclusion in this case, the respondent coroner.
Could you speak up a little?
Yes, I'm so sorry.
Yes.
The coroner, the words used by the coroner reflect almost exactly what is set out in the bench book. So to a large extent, the lawfulness of what he did turns on very much the lawfulness, correctness of the approach taken in the bench book. And to that extent, this is obviously not just about the lawfulness of this outcome, but much more broadly about guidance for coroners generally in how they are to approach this practical problem. The coroner's role and the stance he took in the court below and indeed today is one of neutrality in this sense as to what the law properly is about, first of all, the standard of proof for a suicide short form conclusion, and then dependent upon what the outcome or the answer to that is, how it is that a coroner may lawfully and sufficiently elicit the jury's findings to fulfil an Article 2 procedural obligation. And what he has been anxious to portray, and I think it is now already before the court, is the practical problem that coroners face in fulfilling the procedural duty under Article 2, if it is right to say that in those cases where the evidence is not sufficient to record a suicide conclusion, a short form suicide conclusion, if it follows that a jury may not be permitted to record a factual finding on the balance of probabilities as to any element that would be relevant to suicide, the act itself, as has already been said, in most cases the point that was more contentious may be intention in doing the act. If that cannot be recorded, then that does create a problem, a practical problem for coroners in how to fulfil the requirements of the procedural duty. And although my learned friend Ms Monaghan says, well, alongside findings of fact in a narrative conclusion, failings by the state, to give an example, a failure to start the act process could be recorded as a failing. The point at which the problem may really arise, practically, is that that alone isn't sufficient. The obligation on the coroner, if the evidence is there to justify it, is to record or elicit from the jury also whether any failings by a state agency have caused or more than minimally contributed to the death. And it's the finding determination about causation that may most regularly require the decision maker also to have found as a fact what intention may be. The facts of this very inquest illustrate that, because of course the jury was invited to consider whether failures on the part of the prison had more than minimally contributed to the death, and they looked particularly at what steps had been taken to prevent an act of suicide. And within the course of their findings, as they recorded them, they made a finding that there had not been a causative failure because of what they found about the deceased's intention. And it won't be every case, but none of the problem is that there will be cases that in the absence of a factual finding as to what the intention was, it is impossible for the jury to go on to make a sensible
Well, to
finding.
take an obvious example, cases of reasonable conduct on the part of prison authorities will be geared by reference to what they knew or ought to have known. And one obvious point is, did they know what the particular prisoner was intending to do? Because if he said, if you don't get that by tomorrow, I'm going to do myself away, or words to that effect, it's difficult to avoid knowledge of his state or her state of mind.
It is, and within the range of, and what intention, of course, also revealed is whether, for example, there was a deliberate act, but it was a cry for help, or it was a deliberate act in a scenario where the person involved was messing about, attention-seeking, any number of scenarios, but whether a system designed to prevent suicide ought to have been used, and if it had been used, whether it would in fact have prevented the death, can't be analysed, or factual findings, determinations can't be made without first deciding in this particular factual scenario what impact would it have had on the absence of taking action, what does that have. That's really the key practical problem, and the coroner's assertions and involvement below and in putting in the respondent's notice to, if I can put it this way, keep alive the possibility that the way forward, the way to deal with this practical problem is as set out in the bench book. It has not been his intention to seek to persuade the court one way or other as to what the underlying legal test ought to be, or indeed what the outcome going forward ought to be. But it is simply to highlight that there is this practical problem. And in the absence of a solution, that is going to be very difficult for coroners, because this is not an unusual scenario with which to be faced. And the way it was put below, and the reason as I say, the respondent's notice was put in at all, is that if the standard of proof for the short form suicide conclusion is indeed to be the civil standard, then the problem falls away. But if it is not, and if the standard is the higher criminal standard, then one goes back to how the coroner sought to put it below, which is simply that what is set out in the bench book is a practical way forward to enable the short form conclusion of suicide to remain as a statement that this coroner or jury are sure of the act and intention, and therefore it may be called suicide. But if they are not, then nevertheless the obligations, procedural duty under Article 2 can be met through a narrative conclusion, and a narrative conclusion is to be recorded, the guidance says, on, Form 2 says, on factual findings reached on the balance of probability. And what must be recorded in that narrative conclusion to satisfy Article 2, first of all, are those issues, disputes that lie at the heart of the case. And that's likely to raise both whether the act was the deceased person's own deliberate act. That may need to be recorded, not least to exclude the possibility of any third party involvement. But also likely to necessitate a finding as to intent. And to the extent that it doesn't, the extent to which one puts it, maybe one answer is simply to say, yes, something has to be recorded in order to satisfy the question of whether there was a state agency failure that contributed to the death, and is one way forward to record that, but simply direct the jury that although they must find in their discussions, they must make a finding as to intention in order to inform their decision making about the state agency's conduct and its causative role, if any. But they may be directed that they simply mustn't record that finding. And that is also one way forward. The only could be said about that is, of course, it may be implicit from what is found and recorded about any state agency failure and its contribution to the death, may be implicit what their finding as to intention must have been from that. So although it may not appear then on the face of the record, if it is a decision that the finding of fact that the jury has had to reach as part of its thinking and conclusion, could it be said that it ought to be there not least for transparency and because it may be clear anyway. But there are perhaps the nuances of how best to address the practical problem. But none of that I don't think it is new. I mean, Scott has made some of those points already. But I did want to emphasise that in raising the problem, the coroner before the intervention of the chief coroner was doing so very much in order to ensure that the practical problem for coroners was highlighted, and that whatever is decided about the underlying correctness, the legal test, if it isn't to be a change in the civil standard, then so far it doesn't seem to have been a different practical way forward other than what appears in the Dutch protocol. I don't think I can assist further unless you'd like me to comment on any...
Could I just raise one point with you, if I may?
Yes.
I understand these practical considerations you've raised,
Yes.
which obviously, if the Divisional Court is right, fall away, but it was wrong there. But do these same practical considerations apply or potentially apply to unlawful killing cases on the assumption that the criminal standard is the applicable standard?
They don't apply as starkly.
So on the ground, it's the suicide cases that would give rise to the problem, but you don't see the unlawful killing cases as giving rise to such a problem.
As a matter of practicality,
Yeah.
They don't apply as starkly, and it may well be that that is because...
So as starkly is rather...
as regularly, perhaps I can put it that way. What I'm trying to say is that in those cases, whether it be in a prison or a mental health setting, where the death has resulted from the deceased's own act, then inevitably the coroner or the jury coroner first of all must consider whether suicide is something that needs to be recorded or whether the evidence is sufficient to ask the jury to consider it. If the act is within a detention, in other words, prison or a mental health detention, under the Mental Health Act.
Sorry, could you speak up a little?
Yes, I'm so sorry. If the act has been committed in a detention, whether that be prison or under the Mental Health Act, there may well then be questions to be asked about whether there was any failure by the relevant state agency to prevent that deliberate act. And that is why my submission, this particular problem arises regularly for coroners. In an unlawful killing scenario, and one can of course think of many different sorts of examples that may raise the question of unlawful killing, it arises less regularly, or what arises less regularly is a situation where it is necessary to make a finding of fact relevant to the unlawful killing, purely for the purposes of Article 2. That perhaps is the distinction between the two. Whereas in a suicide case, may be particularly concerned, or an act of self-harm, may be particularly concerned with whether the state agency acted properly to prevent that act of self-harm, then that question of intention arises much more regularly as a necessary matter that has to be decided upon as a finding of fact to enable the failings of the state agency, or potential failings, to be determined, and for a decision to be made as to whether that was causative of the death. So I think I'm really just saying that on the fact, the likelihood of the facts, the problem, the practical problem, arises much more regularly in relation to deaths from self-harm than it would in any form of unlawful killing scenario.
Thank you very much, Ms. Hewitt.
The question of remedy hasn't been touched upon at all, and I know my friend Miss Monaghan, I don't know whether she wishes to go back to it. There is a suggestion that it may be left to one side until the outcome of the court's decision.
Well, we hadn't given that. Speaking myself, hadn't given that any thought. Perhaps I should have. But what is your submission? Well, would you say you really got to see what the reasoning is?
My submission would be that if the Divisional Court's approach is thought to be right, then they have dealt very clearly with that at the end of the judgment, where it is said, therefore there is nothing wrong with the direction that was given.
You're quite.
If it is thought not to be right, and the standard is the criminal standard, I have addressed at the end of my skeleton argument that position suggested why it may be that the court would think that one way forward, if the direction was shown that way to have been wrong in law, would be simply the removal from the record of inquest of what may be thought to be the offending words. That being done under the court's powers in section 31(5) of the Senior Courts Act. And if I may take a lady first of all to the record of inquest, perhaps to explain what I would suggest. It's the very final page, page 267. Of the court.
Really, just the first sentence on 267, is that right?
First sentence, exactly.
So
And at the bottom of the next paragraph, where it's nor increased vigilance generally would be likely to prevent the death, there are the words, given what we believe was James's intent to end his life. My submission would be that the removal of the first full sentence that was stopped at the top of page 267, and the removal of those final words at the end of the next paragraph, would take out of these findings the specific references to the finding on intention on the balance of probabilities. That would leave the record of inquest standing, as I understand, Ms. Maughan would suggest it is the correct way forward, which is that for the purpose of a narrative conclusion needed for Article 2, that it is permissible for the jury to record findings that may be based upon a decision on intention reached on the balance of probabilities, as long as it is not, or as long as that decision on the intention is not expressly recorded. And my suggestion is that that is court has the power to take that step under section 31(5) of the Senior Courts Act. It comes to this court substituting a part of the decision-making process, which is open, exercisable only if the decision in question was made by a court or tribunal. It is right to say that would have to treat not only the coroner's direction, but also the jury's finding as decisions of a court or tribunal.
Well, face of it, that's plainly what it is.
The decision is quashed on the ground that there's an error of law, and that without the error, there would have been only one decision which the court or tribunal could have reached. And so if the conclusion of this is that standard of proof is the criminal standard, and that the way forward for coroners is to direct a jury to Article 2 purposes, that they may have to reach a decision on intention, that they must not record it, but must simply go on to record any findings that flow from it. And if that direction is the one that ought to have been given, and had been given, then in my submission what one would expect to see is what is recorded there, save for the words that...
Well, we'll hear in a moment what Ms. Maughan has to say about that. Thank you very much. It was just one moment. Ms. Monaghan, unless we're going to be a very substantial amount of time, we can sit a bit late if we have to.
I'm going to be a very, very short amount of time.
Knowing you, Ms. Monaghan, I didn't expect you to be.
Well, I'm going to firstly adopt everything that Mr. Hoff said that's supportive of my submissions, and not anything else. So I trust I can do that, and I certainly won't go back there. And I leaving aside the joking, I do so with respect, and it would be futile of me to repeat them all. So just a couple of points, if I may. First of all, the Section 10 points. In my submission, Section 10 doesn't help, save to show that Parliament anticipated that at least in some cases the criminal standard would apply. But it doesn't limit the operation of Section 10 to homicide cases. And of course there may be cases where there is a finding of a criminal act in the course in particular of a narrative conclusion or a questionnaire which does not result in a finding of unlawful killing. So a typical example would be there was an assault, he was battered over the head without good reason with a truncheon, but it wasn't causative of death, for example. Or assisted suicide is the other possibility. In such circumstances, there wouldn't be a requirement to name. Indeed, there'd be a prohibition on naming, but there may well be a finding of an unlawful act, a criminal act. Secondly, as to practicalities, and really I think this has probably been picked up by Mr. Hoff, but just to emphasise, if I may, because I think with the helpful position he's taken, it does go both ways, and I would like to emphasise that the difficulties with different standards of proof operating within the same inquest hearing arises in the context of unlawful killing as well as suicide. There may be cases where all the elements of unlawful killing are established, but the jury conclude only that probably excessive force was used, but that may nevertheless be something that's important to record, because it may, for example, be that the jury conclude that there ought to be better training and so on. And as Mr. Hoff has already said, there is no distinction in this context between a narrative and a short form. I think nobody is suggesting that a different test should apply. And so a coroner will be left with asking whether or not the elements of an unlawful killing ought to be found, should be found, or could be found otherwise than on the basis of beyond reasonable doubt. There may be different standards to apply, and that isn't uncommon. It may well be that it's more common in suicides, and that may be because suicide is more common than unlawful killing. But as a matter of principle, the difficulty arises, and if it arises across the board. And thirdly, and this is my last point, subject to remedy, thirdly, and Ms Hewitt's anticipated this point because we've had some discussion about it, that is that it is possible for the jury to go through the necessary exercise to find failures by the state without recording the elements of suicide on a balance of probability basis where they're not satisfied beyond reasonable doubt. And that is by them being directed to adopt the approach taken in the coroner's guidance, number 17, which I took you to at the outset, which makes it clear that there's a three-stage process, as indeed there is in a criminal trial. Before the coroner or the jury come to any conclusions, they must, in their own minds, collectively or singularly, make findings of fact. All of those findings of fact don't require recording, just as in a criminal trial, when a jury come back with a murder conviction. They don't set out their findings, but they will be told that they will need to reach certain conclusions before they can return a verdict of murder. Similarly, they will be directed in an inquest that there will be findings of fact they will have to make before they can be satisfied on balance of probability, for example, that there were state failures. They needn't record those. So there is a way through this which doesn't intrude upon the opportunity to make those findings that will be necessary to discharge the Article 2 obligation, where there may be state failures, may not be state failures. Those are the only 3 points I had to make by way of reply in substance. I'm just going to ask Mr Bunting, if I may, if I've missed anything. He's told me no, so I can blame him if I have. And the last point was remedy. And as Ms Hewitt also anticipated in her submissions, I had thought, and we'd had some discussion about this, that we would wait until at least the draft judgment is handed down for the purposes of seeing quite what this court says. There would be some concern about just conceding where there is a jury conclusion, a narrative jury conclusion, that bits can be just taken out of it, just as would be the case were this handed down in an inquest. Well, the court's function is not to redact jury conclusions or substitute them with conclusions themselves. This is not a tribunal in the ordinary way. And so we would certainly be keen to have the opportunity to review a draft judgment at least.
Well, you always have the right, although we spend our time saying that the purpose of circulation in draft is not to change the substance, but of course you can always propose a draft order. Having said that, this is, speaking for myself, I find it a little bit hard to see how if you succeed on the basis on which you have argued it, there's anything more you need to know in order to say what relief you're entitled to.
Well, I hear that, my lord, if I can say it like
I
that.
don't know whether my lord, my lady may think I'm being too tough, and I certainly don't want to. But I think we'd like to hear, what, on the face of it, what Ms Hewitt suggests seems reasonable.
Well, on the face of it, it may be the way through it. We would like to explore whether or not the statutory provisions that Ms Hewitt has identified permit a court to redact a jury conclusion as opposed to a court's determination, that would be a step further, and certainly I would be this is not intended in any sense to be unhelpful, but I would
You want more
be
time.
reluctant to concede it on my feet, particularly as we had anticipated this would be something that we might wish, we had understood that this would be something we might want to take up. And my Lord, may I say that I trust that you can be sure that we will be sensible about it.
That's something I've never had any doubt about this morning. Can we just have a quick word? My Lord and my Lady are much less tough than I am, were content for it to be dealt with, or they're content, and so am I, therefore, for it to be dealt with in the interval between circulation of draft and the handing down of the judgment. But you may have to, you might be sensible to do done some thinking before then, because otherwise you may find yourself sitting up all night. Because you don't get that long in between the two.
Why not just thinking about it, but also discussing it, Monsieur?
Yes, and also taking instructions. And given the context for this hearing, of course, the taking of instructions has to be very delicately dealt with.
Of course.
While relief doesn't really concern my client, may I just raise a point of general concern about what's been raised? Section 31(5) permits the court to substitute its own decision for a determination of the lower court, where there is only one right answer, in short, where if the legal approach had been taken correctly, there would only be one right answer. Now, of course, what this court can't say is that there is only one right answer to the entire question of how the person died. There may be lots of right answers about the adequacy of act procedures and so on. But it's whether you can carve out the question of intent and say that that is a separate decision of a jury which you can substitute, even though it forms part of their answer to a composite how question in the statute.
Yes.
And for my part, that's a point which is of some significance to practitioners. And
well, you'd better be part of the discussion. I was slightly surprised, but only because I hadn't thought about it, that Miss Hewitt thought that the vehicle had to be section 31(5). Couldn't one simply quash the finding insofar as it made a finding about intent?
That's what I've seen done before section 31(5) came along. So it may be possible that can still be done.
Well, it looks like this may be quite a substantial point, though it may not. So let's all of us hold our fire and think about it more. You think about it more, and we'll think about it when you have provided us with the arguments.
I'm also aware that I owe you a note if I can find anything about practice and procedure.
Well, it may be a blind alley, but you never know. So I think if you could, as soon as possible.
If I can find something, you will get it, I would imagine, tomorrow.
Yes. Well,
And
if
you
it
would also submit the bits of the bench book relating to unlawful killing.
I shall indeed.
And just, I seem to put somewhere that the parties are all agreed in advance, no one's going to recover costs from anybody in any circumstances on this appeal, is that right?
That's, I think, regrettably.
It's agreed.
That's the standard position where of course the respondent is saying.
Does that mean, I haven't, you said regrettably, does that mean that you're acting pro bono?
No, it means we might as well be acting on legal aid. High cost case plan. Case plan, so enough to buy
but you would have got an extra plaudit if you'd been acting pro bono, but you
No,
weren't.
I can't claim that.
Well, we're very grateful for the extremely helpful skeleton arguments and oral submissions, and all work's gone into this case, both those from whom we've heard and those behind them from whom we haven't. And as I've already said, we found the submissions of Inquest helpful as well. And this will be dealt with in the usual way. We'll reserve our judgment. Drafts will be circulated. There'll then be an opportunity, as we've already trailed, to consider consequential matters. But the judgment will then be handed down at a hearing which the parties need not attend. Thank you all very much.
We'll try